The very foundation of this argument is that the government has and should have absolute power. The Constitution and our laws are only a suggestion. This redistricting effort in Missouri specifically would be an astronomical expansion of big government power over Missouri citizens. And this effort would, no surprise, cost a whole lot of money. Let's do a deep dive on redistricting. My name is Elad Gross. I am a civil rights attorney in Missouri. I often sue the government to protect our Constitution and individual freedoms. Today, we are looking at redistricting congressional seats. What is redistricting? Well, it's the process by which we determine which people are represented by which elected officials. Normally, this process happens every 10 years after the census. We count up all the people in our country, redraw districts so that each one in each state has about the same number of people in it, and then we go about the next decade. Right now, there is a national conversation about redistricting for Congress before the next census. The White House is very supportive of states redrawing their congressional districts to add more Republican-leaning seats. I wonder why. Some prominent Democrats want to counter this push by adding more Democratic-leaning seats. This is all leading up to the midterm elections. With such a slim majority in the House of Representatives, and with so much congressional action determined by party affiliation, redistricting is a really big deal for national legislation. To understand redistricting, we first need to understand the source of that redistricting power. Let's start with the U.S. Constitution. The federal Constitution doesn't say much about redistricting. Article 1, Section 2 of the Constitution, where this power is included, is probably most famous for what it no longer includes, the 3/5 compromise, where slaves were counted as 3/5 of a person for the purposes of apportioning representatives. That sentence was eventually repealed. All the Constitution now says is that there has to be an enumeration of the population, that the count has to happen every 10 years, that every state gets at least one member of the House of Representatives, and the number of people represented by a member of Congress has to be at least 30,000. Article 1, Section 4 leaves most of the power of choosing representatives and senators up to the states. So the U.S. Constitution really doesn't help explain the limits of redistricting. It sets some baselines. For example, the Constitution has been interpreted as requiring roughly equal representation. You might have heard of the phrase, one person, one vote. If you haven't, you sure will. Well, I guess you just did right now. That's why each district within a state has about the same number of people within it. That's true within a state, not necessarily between states, because there's only so far we can go with all of this. And that's why when a state's population decreases enough, it actually can lose a seat in the House of Representatives. And a state with enough of a population increase can gain one. So the Constitution gives us some basic rules, but that's about as far as the federal Constitution goes. And I say federal Constitution because there's another group of constitutions that's really important, state constitutions. The states have their own constitutions, and they have a lot of power to determine this whole process. Some states have their state legislatures draw the districts, like Missouri. Others have special commissions do it. And this is where we can find a lot of answers as to what is legal and what is not in the redistricting process. And we will take a look at Missouri's special constitutional provisions in just a little bit. There is another big source of authority, though. Laws. There are laws out there related to the redistricting process. Maybe the most powerful one is a federal law known as the Voting Rights Act. That law was designed to prohibit the discriminatory drawing of districts. The Voting Rights Act is a whole topic on its own, but what's important to know is that the Voting Rights Act has been greatly weakened by court decisions in the last decade and a half. Now, it's not entirely gone. Courts are still finding that some districts are impermissibly drawn to reduce minority voting power, and the Supreme Court has ordered briefing on this topic. It's definitely an area to watch. And that takes us to our next place to look for rules about redistricting, the courts. Courts interpret the laws and the constitutions to figure out what is and what is not legal when it comes to redistricting. Sometimes these cases end up in federal court and could go all the way to the United States Supreme Court when they involve federal laws, like the Voting Rights Act, or federal principles, like one person, one vote. Other times, these cases go through the state court systems, especially when they involve state constitutions. Remember that states can set a lot of these rules through their own constitutions. So let's look at one of those states in particular, my favorite one, Missouri. Missouri is a special case, not only because we are a special state, but because we have some specific provisions in our state constitution that other states just do not have. Article 3, Section 45 of the Missouri Constitution discusses congressional redistricting. Here's what it says. When the number of representatives to which the state is entitled in the House of the Congress of the United States under the census of 1950 and each census thereafter is certified to the governor, the General Assembly shall, by law, divide the state into districts corresponding with the number of representatives to which it is entitled, which district shall be composed of contiguous territory as compact and as nearly equal in population as may be. So that's pretty clear. That was a very long sentence, too. Redistricting occurs when the number of representatives we get, according to the census done every 10 years, is certified to the governor. It doesn't say that the governor or the legislature or anyone else can redistrict the state anytime they want to. The language is so plain and so clear that despite the many times Article 3, Section 45 has been the basis of a lawsuit over whether a district was drawn correctly, the issue of redistricting in the middle of a decade without a census has never made it to an appellate ruling. That issue has come up, though, in other redistricting situations. Congress is not the only elected office based on districts that have to be redrawn due to population shifts. State legislative districts also have to be redrawn. Take a look at Article 3, Section 10 of Missouri's Constitution. It says, "The last decennial census of the United States shall be used in apportioning representatives and determining the population of senatorial and representative districts. Such districts may be altered from time to time as public convenience may require." That last line, allowing changes to districts as public convenience may require, is language not included in the congressional reapportionment. So this language about state legislative districts, state House, state Senate, sure looks like it gives the government way more latitude to redistrict at times of its choosing. But is that true? No. Missouri Supreme Court ruled in 1955 that even with this more permissive language, only one redistricting is permitted every 10 years. Redistricting isn't supposed to be done for political reasons, but for population reasons. An Attorney General opinion from the same year entirely agreed with Missouri Supreme Court. So here's where we are in Missouri. The state constitution clearly says redistricting happens after the census. A similar but more permissive provision of the state constitution also only allows redistricting after a census for state legislative districts, and no authority anywhere gives Missouri government the authorization to redistrict without a new census for political reasons. So what does this all mean? This means that the effort to redistrict in Missouri is likely unconstitutional, and it may very well violate the Federal Voting Rights Act, too. Missouri has 8 congressional districts. 6 are currently held by Republicans, 2 are currently held by Democrats. The effort to redistrict Missouri focuses on Congressional District 5, an office currently held by Emanuel Cleaver that covers Kansas City. Essentially, Kansas City, under this plan, would be split into multiple districts, placing more Democrats in heavily Republican districts while keeping those districts Republican-leaning, and then creating a new District 5 that includes a lot more Republicans. The goal would be to replace Cleaver, a Democrat, with a Republican. Representative Cleaver won his last election with about 60% of the vote. The Republicans in nearby districts won with about 70% of the vote. So those Republicans nearby could absorb more Democrats and still have a strong chance of winning. Overall, Missouri is about a 60-40 state, meaning that about 60% of people vote Republican and 40% vote Democrat when you look at the state as a whole. That hasn't always been the case. Until 2016, Missouri had elected Democrats in statewide office, but that is no longer true. Our congressional delegation is a bit more slanted than 60-40, if you haven't noticed already. Instead, with 6 Republicans to 2 Democrats, the congressional members from the state are 75% Republican, more than 60, and 25% Democrat, less than 40. In a 7-to-1 map, like the one that's being proposed in this whole thing, we would be 87.5% Republican and 12.5% Democrat. Additionally, changing District 5 may violate federal law. The Voting Rights Act ensures that members of a protected class have the same opportunity as other citizens to participate in the political process and elect representatives of their choice. Right now, the population of District 5 is about 22% black. The new map would be challenged, most likely, under federal law if District 5 is redrawn to eliminate the voting power of black Missourians. That's what the Voting Rights Act does. That has happened and is currently happening in other states right now, and the Supreme Court has so far upheld this requirement. But again, this is an area to watch because the Voting Rights Act has eroded over the last decade and a half. Other states have different laws and different constitutions. What is legal in one state is not necessarily legal in another. So mid-decade redistricting is legal in other states, but not in Missouri. The effort to redistrict Missouri is unconstitutional, may very well violate federal law, and would skew Missouri's congressional delegation to be even more out of alignment with the state's overall partisan split. But all of this goes way further than just the issue of redistricting. The very foundation of this argument is that the government has and should have absolute power. The Constitution and our laws are only a suggestion. This redistricting effort in Missouri specifically would be an astronomical expansion of big government power over Missouri citizens. And this effort would, no surprise, cost a whole lot of money. The legislature has the power to draft and approve a bill to redraw Missouri maps after the census, and the governor has the power to sign that bill into law. We don't have a new census, so that's a big problem, but we also don't have an ongoing legislative session since Missouri's state legislature is part-time. Missouri's governor can call an extraordinary session of the legislature to bring them in to draw maps under Article 4, Section 9. Alternatively, the legislature could call its own special session, pretty much the same thing, if the governor doesn't under Article 3, Section 20b. A special session, no matter who's calling it, costs money. Now, maybe someone from Washington, D.C., out of the kindness of their heart, will offer Missouri a free map to use to redraw our districts. So maybe that won't cost any money. But the litigation that follows certainly will. Our state government will be in the position of defending an unconstitutional process with taxpayer money supporting the defense effort, the expert witnesses that the state will have to hire, and the attorneys who could have spent their time doing something else, like saving Missourians money by suing scammers or prosecuting public corruption. You know, those little things. And then when the state eventually loses, we may very well all be on the hook as taxpayers to pay the winning attorneys and their costs. Also, someone in Washington, D.C., with a half-baked plan and no understanding of how Missouri works or how our laws work can try to get another vote out of us. Now, there are three ways that this process ends. First, a lawsuit, which can be brought by Missourians as individuals, challenging the constitutionality of the redistricting law that the legislature comes up with and that the governor signs. Number two, a referendum, which gives Missouri voters the power to collect signatures on a short time frame and put a law passed by the legislature up to a vote of the people. This just recently, actually not too long ago, just a few years ago, happened with the right to work anti-labor legislation that was overwhelmingly overturned by the referendum. And number three, the legislature or the governor could decide not to move forward. Good luck to all of us with that one. The era of big government is apparently here, and now Missouri, with a long history of being at least a bit skeptical of the folks in Washington, D.C., and even our own in Jefferson City, has become the front line in the battle to see just how big government gets.